Hello and welcome along to today's webinar, HR Holiday Headaches. My name is Rachel Lamsley and I'm a Senior Employment Law Advisor here at Ellis Whittam. So before we get started, a little bit of housekeeping. To listen to today's webinar, please use your computer speakers, and if you're having any trouble at all, do pop it in the questions box and I will be able to come back to you after the event. There will be a recording available, so if you have missed anything, don't worry, you'll be able to catch up after the event. So for those who are unfamiliar with Ellis Whittam, we provide high quality, fixed fee employment law and health and safety advice. We employ qualified solicitors and health and safety advisors who develop one-to-one relationships with our clients as we provide you with a named advisor to help you along your HR and health and safety journey. We don't just advise, we provide hands-on support, and we have a range of additional services that employers can take advantage of. We're currently supporting more than 10,000 UK employers, from startups to national brands, and we really are experts in our field. Our clients are pretty happy with what we're doing as well, and we currently have a more than 95% client satisfaction rate, something we're really proud of here at EW. So what are we going to have a chat about today? Well, we're going to have a look at statutory entitlement, declining, cancelling and forcing annual leave requests, those employees pulling sickies, family-related leave and its interactions with holidays, bank holidays, and we'll have a chat about a holiday policy. As with every holiday season, and to be honest, all year round, you need to ensure your business demands are met and there's not a mass exodus in your workplace during any particular period. But in order to plan, you need to understand your rights as an employer and your obligations. You also need to think about balancing the needs of employees' right to rest and recharge their batteries with the needs of the organisation to ensure that there's sufficient cover. Perhaps you or many of your line managers will have experienced the classic scenario where an employee requests some time off only to be refused as others in the team have already booked the time off. But how do you deal with that? Well, today I'll help you navigate through all things annual leave and help ensure that you deal with annual leave requests and annual leave generally in a fair and consistent way. So let's start at the beginning. What are the basic rights? Well, most workers are entitled to 5.6 weeks paid annual leave each year, and that's the equivalent to 28 days, including bank holidays. This right begins to accrue from day one of employment, which means that the employee doesn't need to be employed with you for a particular length of time in order to accrue rights to annual leave. A part-time worker is entitled to a pro rata of the 28 days holiday, which is based on the number of days or hours that they work each week. This can be a tricky calculation if employees perhaps work different hours on different days. Here at EW, we can help make sure that you give your workers the correct amount of annual leave and don't come a cropper with any miscalculation. A worker's start date is pretty important for the calculation purposes of annual leave, because if an employee starts work perhaps partway through the year, then their entitlement will be prorated depending on how much they've actually worked in that holiday year. So now we've got the basics. What are your rights as an employer when it comes to holiday entitlement and pay? Well, two of the most persistent myths I hear are firstly that an employer can't refuse a request for annual leave, and secondly, they cannot cancel pre-approved annual leave. Actually, an employer has more say over annual leave than you might actually think. So let's take a look. The starting point is that an employer can refuse a request for annual leave. For example, many of your employees in the same team or department may wish to take annual leave at the same time, particularly over the summer. However, it might not be feasible for you to grant 2 or 3 requests, as you need to ensure that your business needs are met. In order to say no to a request, you must give the employee counter notice, and the length of notice you give must be equivalent to the period of leave that the employee was trying to book. So, for example, someone wants 5 days off. The counter notice needs to be at least 5 calendar days before the date on which the leave was due to start. It's also possible to oblige employees to take annual leave at certain times. For example, if you have summer closed down or a few days extra off at Christmas, they might be particular times when you need staff to take their annual leave. Alternatively, there may be times when you decide to prohibit employees taking annual leave, perhaps at a particularly busy time of year, which require all hands on deck. As an employer, you may give notice ordering a worker to take statutory holiday on specified dates. If, for an example, you want the employee to take 2 weeks annual leave, the notice you must give must be at least twice the length of time of the period that the worker is being ordered to take. So, in this example here, you want the individual to take 2 weeks leave. You must therefore provide at least 4 weeks notice to the worker. It's worth noting that whilst there's no explicit requirement about the form that this notice must take, it is good practice to do this in writing to show that you've completed the requirements. You may also find yourself in a situation where you have to cancel leave. For instance, a big project with a tight deadline has just come in and you require all your employees to work and get the task completed. The law does allow an employer to cancel an employee's annual leave that you've previously approved. To do this, you've guessed it, you must provide appropriate notice, and the length of notice must be equivalent to the period of leave that the employee has planned to take. This means that if an employee was due to take 5 days annual leave and you wish to cancel it, you must provide a minimum of at least 5 calendar days notice before the date on which the leave was starting to take place. There is a word of warning here though. Before cancelling the leave, you should think about all options. Make sure that before you cancel it, you've got a clear business reason why, and only do it if absolutely necessary. If you cancel someone's leave, which means they can't take a booked holiday and they perhaps suffer financial loss, they may actually be able to argue constructive dismissal in that there's been a breach of the implied duty of mutual trust and confidence, something that we obviously want to avoid. This could also have some serious repercussions for staff morale, so I'd always suggest that you take advice before cancelling annual leave. Don't forget, you mustn't cancel annual leave if it means that the employee can't actually take their full statutory annual leave entitlement in that leave year. I think that it's always a good idea to have rules about booking in annual leave in the employee's contract or handbook, and I'll give you some hints and tips about what to include in a holiday policy later on. So what next? Well, at this time of year, we often get calls about staff pulling a sickie after annual leave requests have perhaps been denied. A big and costly mistake some employees make is seeing a fantastic deal and booking the hotel, flights and car rental without getting authorization from their manager. Cue an unhappy employee when their manager tells them that 2 of their colleagues are already off on holiday and you can't allow them to take the time. Dealing with these issues costs your business time and eventually money, and it prompts a lot of questions. What do you do to prevent this occurring? What do you do if you hear rumours swirling around the workplace that the employee will pull a sickie? Or what do you do when you receive a call saying the employee is too sick to come in? Well, prevention is definitely key. Make sure your sickness absence policy, it's clear that employees shouldn't request leave and that employees should request leave before they go and book any of their holidays. You should encourage employees to book early to avoid disappointment and to collaborate with each other to coordinate leave. If you close in the summer or at Christmas, or you decide to prohibit employees taking annual leaves at particular busy times, remind employees of these rules. Make sure you consistently hold return to work interviews as well after each period of absence. If people are aware that this is the company policy and it's always followed, it may help deter people from pulling sickies. After all, nobody wants to face intense questioning after they return to work. You should keep accurate records of these interviews, as it will help you identify any patterns or trends. The second thing to help you is address the rumours. If you've heard through the grapevine that the employee intends to call in sick, you should hold an investigation with them to discuss what has come to your attention and whether there's any truth in the rumour. You should also remind them that any authorised absences may result in disciplinary action if they actually turn out to be unauthorised. In your employee handbook, you should have a provision regarding how employees who deliberately fail to attend work without a proper excuse or in breach of management instructions will be committing an act of gross misconduct, which could result in a dismissal without notice or payment in lieu of notice. This can often do the trick and deter them from feigning sickness to get the desired time off. If you're unsure how robust your handbook is, then get in touch with us and we'll be able to help you review that. The third thing I think we need to have a think about is actually taking action. If they've gone ahead and called in sick, you should carry out that return to work interview to probe them into the reasons for their absence. Rather than openly accusing them, you should raise the issue that it could be seen as not a genuine absence, as it occurred at the same time as they wanted to go on holiday. Don't forget, if they've been away from the workplace for 7 days or more, they're going to need to provide you a fit note from their GP. The thing here is we've got to let staff know that we will take action and that things won't go unnoticed or unactioned. There's much more to know about return to work meetings in these sorts of situations, so do take advice. So I wanted to do a quick roundup on family leave related time off and how this actually interacts with annual leave. You may have your own rules relating to this, but I'll just cover the statutory minimum. So, from a maternity leave perspective, all contractual terms, except for those relating to remuneration, carry on during ordinary maternity leave and additional maternity leave. This means that the right to accrue annual leave also carries on. For shared parental leave, adoption leave, paternity leave, the worker actually gets the same as someone on maternity leave. Therefore, annual leave continues to accrue. But what about unpaid parental leave? Well, a worker on unpaid parental leave doesn't have the right to benefit from contractual holiday arrangements, but they will continue to accrue leave under the working time regulations. But what about carryover? Well, there's lots to be said in respect of carrying over annual leave entitlement, so if you've got any questions in respect of that, do get in touch. Bank holidays are sprinkled throughout the year, but do you really know how to deal with them? Do employees have an automatic right to the day off? Well, the answer is no. Whether an employee works or is given the time off will depend on their contract of employment, or perhaps the custom and practice of your organisation. The employee's contract may say something along the lines of that in addition to all bank and public holidays, the employee is entitled to 20 working days of holiday. Alternatively, the contract may say that the employee's annual leave entitlement of 28 days is inclusive of bank and public holidays. If you have any questions about your employee's contract of employment, then do take advice. We can review and update your contracts to ensure that they're robust, up-to-date and legally compliant. In many cases, employers do grant the employee time off for bank holidays. However, in some sectors, the nature of their business means that employers will need their employees to work on bank holidays for commercial or operational reasons. This might be the case in retail, transport, or public services. Another question I often get is, do I need to pay a worker more for working on a bank holiday? Well, again, the answer is no. Employers are under no legal obligation to pay extra for working on a bank holiday, but an employee may be entitled to more if this is stated within their contract of employment or based on customary arrangements. I'm sure you have a worked out pattern here, but the contract is key. What does the contract say in respect of pay and taking bank holidays? For example, an employer might decide to pay the employee time and a half or double pay simply for working on a bank holiday. So what should you include on your holiday policy? Well, I've set out for you a few examples. It may set out how much notice an employee needs to provide when booking annual leave. Unless otherwise specified in the contract or handbook, the employee should provide you with notice which is at least as long as the leave that they are requesting. If they request 1 week of leave, they should provide you with at least 2 weeks of notice. You could state how the leave must be booked and how many consecutive working days could be booked off. For example, no more than 10 working days. You may also specify how many people could be off in one period of time and how they actually go about booking the annual leave. You should also consider telling employees not to book holiday off without submitting a request and getting authorization from their line manager. And you should also encourage them to book early to avoid disappointment. There's lots of things that you can include, so it's worth having a review of your holiday policy to make sure that it's fit for purpose. So, what are the risky areas when it comes to holidays? Well, what about 0 hours and casual workers, commission and overtime, not to mention sickness absence? With all of these issues, the way we treat holidays can vary, and so it's always worth getting in touch if you've got any particular questions about these sorts of areas. So that brings us to the end of our webinar today. Thanks so much for joining me. I've really enjoyed having you on board. If you've got any questions, then do pop them in the questions section and we'll come back to you with the answer. Here at EW, our employment law advisors and health and safety consultants are on hand to help you understand your legal obligations and make any process easier and smoother. And so if you've any questions about today or our services generally, then get in touch. Our contact details are right there for you and they'll be in our follow-up email. Why not join me on our next webinars? We have the Employer's Guide to Contracts of Employment on the 18th of July, followed by a flexible working webinar on the 10th of August. So do feel free to join me on this. The details will be in the follow-up email. I hope you have a great rest of your day.